7 words. That is all it took. Services no longer needed. Sent by text message at 11:14 on a Tuesday morning to a woman who had given 19 years of her life to that family. I have sat in this chair for over 30 years. I have heard things in this courtroom that would keep you up at night. I have seen genuine remorse. I have seen breathtaking arrogance. I have seen people walk in here believing the law was something they could bend around their own convenience. But I had never, not once, in 3 decades, seen a man walk into my courtroom to demand money from the woman he had just dismissed with a text message. Not until that Tuesday morning. If you believe that 19 years of a person's life cannot be erased by 7 words and a timestamp, stay with me, because what happened in the next 45 minutes changed something in this courtroom permanently. And if stories like this one matter to you, stories about ordinary people who refuse to be invisible, please subscribe right now. This channel exists for exactly these moments. Her name was Rosa Mendez. She was 64 years old. She arrived before anyone else that morning, before the gallery filled, before the attorneys set up their papers, before the court reporter settled in. Rosa was already there, seated quietly in the front row, wearing a good blouse she had clearly pressed the night before. She held a manila envelope flat against her chest with both hands, like she was protecting something that mattered. She did not have a lawyer. She had a spiral notebook, the kind you find at a drugstore for $2. And whatever quiet courage it takes to walk into a room like this one alone, knowing the person on the other side of the aisle arrived with 2 associates and a practiced attorney in a tailored suit. That man was Raymond Collier. I had reviewed the file before court began. The basic facts were not complicated. Rosa had cleaned the Collier home every Tuesday for 19 years. Same day, same time, $200 a week, a rate that had never changed, not once, in nearly 2 decades. In the final 3 months of their arrangement, those payments stopped. 12 weeks of work, 12 Tuesdays, done in full, never paid. That was $2,400 Rosa came to this courtroom to recover. But Raymond Collier had not come to settle. He had come with a counter-motion. He was seeking $8,000 from Rosa, claiming she had breached their service agreement during the period his house was being prepared for sale. The house, I noted in the file, had sold for $3,400,000. He was suing the woman who cleaned his home for 19 years for $8,000. I called the case. Rosa stood immediately, straight-backed, composed. Collier's attorney stood for his client. The attorney was smooth, practiced, the kind of man who has spent years making unreasonable things sound perfectly routine. He explained that Rosa was not an employee. She was, he said, an independent contractor, engaged on a per-service basis, with no guarantee of continued work, no formal employment relationship, and therefore no protections under wage and labor law. He said her work during the pre-sale staging period had been substandard, that the withheld payments represented a legitimate dispute over service quality, that his client had in fact shown great patience with an underperforming contractor before reluctantly ending the arrangement. He said all of this without blinking. Then he presented the counter-motion, $8,000, damages for breach of their informal agreement. The gallery shifted, not loudly, just that low collective movement a room makes when it has absorbed something that requires a moment to process. I did not look up from the file. I reached across the bench and picked up Rosa's spiral notebook. I opened it to the first page. I want you to understand what I was holding. This was not a legal document. It had no letterhead, no official stamp, no attorney's signature. It was a plain spiral notebook, the cover soft from handling, and inside it were 988 handwritten entries in careful pencil. So neat, so consistent, it almost looked printed. Date, amount, initials, date, amount, initials, every single Tuesday for 19 years. Not one gap, not 1 week unaccounted for, not one correction. Rosa had kept this record herself, without a lawyer telling her to, without anyone suggesting it might be necessary. She had simply understood the way people who have spent their lives in vulnerable positions come to understand things without being taught them. That in a room like this one, the burden of proof falls on the person with the least power. So she had prepared, one careful entry at a time, every week, for 19 years. I read through that notebook in silence, slowly. I wanted the room to feel the weight of what I was holding. This was not just a payment record. This was a woman's decision, made alone, in her own home, to document her own worth, because she already knew, somewhere deep down, that someday she might need to prove it. I closed the notebook. I looked at Collier's attorney. "Counsel," I said, "you've described Ms. Mendez as an independent contractor. Please produce the written independent contractor agreement." He opened his mouth. He closed it. He looked at the table in front of him, shuffled a paper, looked again. He informed me that the arrangement had been informal, verbal, understood by both parties. Consistent, he said, with standard domestic service practice. I noted the absence of any written agreement for the record. Then I looked directly at Raymond Collier, not at his attorney, not at the papers, at the man himself. And I asked him 4 questions. 4 questions. About 45 seconds total. Was Rosa required to appear on a specific schedule, same day, same time, determined by Mr. Collier? His attorney answered, yes, every Tuesday. Did Rosa use cleaning equipment and supplies that belonged to the Collier household stored there on the property? Yes. During her scheduled Tuesday hours, was Rosa, by the nature of this arrangement, unable to take other clients? Yes. And finally, is there a written independent contractor agreement signed by both parties? No. I set the notebook down. I said what the law required me to say, and I will translate it here into plain language. When a worker is told when to show up, uses your tools, works only for you during those hours, and has no written contract saying otherwise, that worker is an employee, not a contractor, an employee. Every legal test this court is required to apply pointed to the same conclusion. The word contractor was not a description of what Rosa was. It was a label Raymond Collier had placed on her after the fact in this courtroom to avoid paying a debt that had existed from the very beginning. Those withheld payments were not a disputed contractor fee. They were wages, and withheld wages have a name. The law calls it wage theft, and wage theft carries penalties. It carries interest. It carries the full weight of protections that exist precisely because arrangements like this one, informal, undocumented, built entirely on the good faith of the more powerful person, are the arrangements most likely to end exactly like this. I was reaching for my pen when Rosa spoke. Your Honor, her voice was quiet, not nervous, not dramatic, just steady. The voice of someone who has been waiting a long time to say something and has practiced staying calm while saying it. May I show you something? Go ahead, Ms. Mendez. She set the spiral notebook aside. She picked up the manila envelope she had been holding since before court began. She unsealed the flap carefully, the way you open something you have been protecting for a long time, and reached inside. She removed a stack of greeting cards held together by a rubber band, an old rubber band. It had left a faint impression on the card at the bottom, the way rubber bands do when they have held something together for years. Someone had replaced it at least once. The mark from the first one was still there. She handed the stack to the bailiff. He brought it to me. I counted them before I opened the first one. 19 cards. 1 for every year. I went through them slowly, from the oldest to the most recent. Each one was a birthday card. Each one was addressed to Rosa, by name, and each one had been signed by Raymond Collier's 3 children. The handwriting on the earliest cards was crayon, big, unsteady letters, the kind a young child makes when they are still learning that letters have a specific shape, a specific direction. You could see the effort in every stroke, the way they pressed too hard in some places, the way they left the crayon lines slightly shaky. By the middle of the stack, it was pencil, then ink. Then in the final cards, the careful, deliberate handwriting of young adults signing something they actually meant. To Rosa, happy birthday. We love you. Every year for 19 years. Kept by Rosa, every single one, carried to this courtroom inside a manila envelope she had pressed to her chest all morning. I looked up. The courtroom had been quiet before. This was a different kind of quiet, the kind that arrives when a room full of people all arrive at the same understanding at the same moment, and no one needs to say it out loud. I looked at Raymond Collier, not at his attorney, not at the papers between us, at him. His expression had been patient all morning, slightly bored even, the look of a man waiting for a process to finish so he can return to his real life. But as I held up that stack of cards, something in his face shifted, just slightly, a tightening, the kind that happens when a person realizes they are no longer in the conversation they thought they were having. I set the cards down on the bench in front of me. "Mr. Collier," I said. He met my eyes. "Your children knew her name." I let that sit. "Did you?" I have asked a lot of questions from this bench. Most people have an answer ready, even if the answer is not true. People prepare. They anticipate. They have something waiting. Raymond Collier had nothing. I watched him reach for a response, a deflection, a reframing, anything, and find only air. His attorney sat completely still for the first time all morning. The associate who had been checking a phone under the table edge put it away. The courtroom did not fill with sound. It filled with understanding. And Raymond Collier, who had arrived with a counter-motion and 2 associates and the unquestioned confidence of a man who has never once been required to explain himself in a room like this, sat in the silence of a question he simply could not answer. I picked up my pen. "Mr. Collier," I said, "Rosa Mendez was your employee. By every legal standard this court is required to apply, the decision to describe her otherwise was made here, today, after the fact, to avoid an obligation that has existed for 19 years. I am addressing that obligation now. You will pay Ms. Mendez $2,400 in unpaid wages. You will also pay $7,200 in statutory triple damages under the state wage theft statute, because withheld wages are not a billing dispute. They are a violation. This statute exists to make the cost of that violation greater than the cost of simply paying what is owed. You will pay $1,800 in accrued interest." I paused. "Ms. Mendez does not have an attorney. This court is appointing one now to file the amended claim on her behalf. The cost of that representation will be added to your balance." I picked up the counter-motion, the one seeking $8,000 from Rosa. "This filing is dismissed. I am entering into the record a notation that this counter-motion constitutes an attempt to use the legal system as a weapon against a wage claimant who arrived here without legal representation. That notation will remain permanently." Collier's attorney was on his feet before I finished the sentence, the first word of an objection already formed. I looked at him over my glasses. "Sit down." He sat. "I am also referring this matter to the State Labor Board for a full audit, not of this case alone, but of every domestic worker engaged in any capacity at any property owned or managed by Raymond Collier over the past 10 years. The pattern before this court: misclassification without documentation, informal arrangements with no written agreements, withheld final wages, followed by a counter-motion targeting the claimant, is not the pattern of a single mistake. It is the pattern of a practice. The Labor Board will determine the full scope of that practice. This court's referral will be filed this afternoon. I set down my pen. We are adjourned. Across the table, Rosa Mendez picked up the stack of birthday cards. She tapped them gently against the surface to straighten them. Then she slid them back into the manila envelope, carefully, the same way she had removed them, and folded the flap closed. She tucked the envelope under one arm. She picked up her spiral notebook and tucked it under the other. And she walked out of my courtroom the same way she had walked in, with that quiet, unshakable stillness, except that something about her was different now. She was lighter, the way a person becomes lighter when they have finally been heard. 3 months later, the Labor Board completed its audit. They found 3 more people: a housekeeper, a groundskeeper, a cook. Combined, they had given 41 years of service across Raymond Collier's various properties. None had written contracts. None had been paid overtime. 2 had been paid below minimum wage in their final years of work. All 3 had been let go without notice, without severance, and without their final wages. The total liability, back wages, statutory penalties, interest across all 4 cases came to $340,000. Collier settled. When Rosa was asked whether she had a preference for how any portion of the settlement funds should be directed, she thought about it for 2 days. Then she came back with her answer. "Name it after the address," she said. "Not after a person, not after a concept, just the address." 4 months later, the Domestic Workers Legal Aid Clinic opened, named as Rosa requested, for 14 Whitmore Drive, the house she had cleaned every Tuesday for 19 years. The clinic provides free legal representation to domestic workers in wage disputes. It has not lost a case. The house at 14 Whitmore Drive sold again the following spring. The new owners called Rosa the week they moved in. Full employee classification, a written contract, health coverage, paid time off. She started the following Monday. Same time she always came, same entrance, same bag. The only difference was what was inside the bag. A copy of her contract, signed by both parties, which she had read in full before putting her name on it. I want to speak plainly for a moment because I think this story deserves it. Rosa Mendez walked into that courtroom without a lawyer, without institutional support, without anyone in her corner who had been to law school. What she had was a $2 spiral notebook that she had bought herself, kept in her own home, and carried to that courtroom on a Tuesday morning, because she understood, without anyone teaching her this, that in rooms like mine, the burden of proof falls on the person with the least power. So she prepared the only way she could. One careful pencil entry every Tuesday for 19 years. That is not just documentation. That is an act of dignity. A quiet, weekly declaration that her work was real, that her time had value, that she would not disappear without a record. The law in cases like this one is not complicated. It only becomes complicated when people with resources decide to make it complicated, when they file counter motions instead of writing final checks, when they attach a label like contractor to a person after the fact to avoid what they always owed, when they send 7 words by text message and trust that the person on the other end cannot afford to respond. This courtroom exists for the moment that trust turns out to be wrong. It will always exist for that moment. That is what it is for. If this story stayed with you, if it made you feel something, share it with someone who needs to hear it. And subscribe to this channel, because we are building something here that takes these stories seriously. Rosa Mendez walked out of my courtroom that Tuesday morning with a notebook under one arm and a manila envelope under the other. Same stillness she arrived with, just lighter. The stillness of someone who prepared alone, waited patiently, and refused, through 19 years of Tuesday mornings, to let her life be invisible.